Recently, the Madras High Court ruled that only Hindus could be appointed in educational institutions that have been established with funds from temples administered by the Hindu Religious and Charitable Endowments Department. Why did it say so? Vanakkam. This is T. Suresh Kumar, and thank you for joining me in this episode of the Hindu Focus Tamil Nadu. Soon after the M K Stalin government took charge in mid 2021, the HR&CE Minister P K Sekarbabu announced that his department would establish 10 arts and science colleges. These institutions, like 5 other institutions that were established earlier, were to come up on temple lands in different parts of the state. This announcement was largely welcomed. However, soon a controversy broke out when an advertisement was placed for recruiting teaching and non-teaching staff. This advertisement said that only Hindus were eligible to apply for the post. Objecting to this clause, a Muslim candidate who had applied for the post of office assistant at the Arulmighu Kapaleeswarar Arts and Science College in Chennai moved the Madras High Court. However, last month, delivering the verdict in the case, the court dismissed the petition and held that only Hindus could be appointed in self-financing colleges and schools that were established using temple funds by the HR&CE Department. In fact, the court said that even such appointees would be deemed to have relinquished the post if they ceased to profess Hinduism. Justice Vivek Kumar Singh in fact said that institutions that do not receive government aid would not fall within the definition of the term state to provide equality of opportunity in public appointment. The judge actually pointed out that institutions that are established with temple funds and whose recurring expenses are met from the fees collected from the students would not fall under Article 16(1) and 2 of the Constitution that prohibits discrimination in public employment on the grounds of religion. Instead, this, he said, would fall under Article 16(5) of the Constitution that provides for appointment on religion basis in certain denominational institutions. Also, Section 10 of the Hindu Religious and Charitable Endowments Act mandates that employees of the department shall be persons who profess Hindu religion, and they are also required to sign a pledge to that effect. Leave aside the colleges. Even in 2011, a private security agency that was run by Christians had moved the Madras High Court challenging a tender notification issued by authorities of the famed Tiruchendur Murugan temple. The court in that case held that it cannot force temples to engage the services of those who are non-Hindus. The court also said that temples cannot be defined as a state so as to compel them to engage the services of non-Hindus. In another case, earlier this year, Justice Srimati of the Madurai bench of the Madras High Court directed authorities to install boards at temples stating that non-Hindus would not be permitted beyond the Kodimaram or the flagpole. She also directed authorities to get an undertaking from non-Hindus who wanted to visit deities, stating that they had faith in the deity and would follow the customs and practices of the Hindus. According to the judge, allowing non-Hindus who declined to follow the faith and customs of the Hindus would affect the sentiments of a large number of Hindus who reverently followed the faith. The judge also said that a temple was not a picnic or tourist spot and ought to be maintained with reverence as per the Agamas. This is, however, not the first time that courts have come up with such ruling. More than half a century ago, the state witnessed the famous case of Kalyan Das versus the state of Tamil Nadu. In January 1970, the government exercised its power under the Tamil Nadu Temple Entry Authorization Act and introduced a rule that permitted the entry of non-Hindus in temple precincts. Kalyan Das of the Tulasi Mutt in Rameshwaram challenged this rule. He argued that this rule permitting non-Hindus to enter temples not for worship but for other purposes did not in any way further the object or purpose of the Temple Entry Act. The Tamil Nadu government on its part had argued that the sanctity of the temple would in no way be affected by allowing non-Hindus to enter certain portions of the temple. The court, however, sought to distinguish between the object of the Temple Entry Act, which was to remove disability of certain classes of the Hindus who were prevented from entering temples, and the new rule that allowed non-Hindus to enter temples. The court said that it is nobody's case that non-Hindus ever had a right to enter temples, not for the purpose of worship, but for sightseeing and as tourists. Such entry, the court said, would negate the very object and avowed purpose of temple entry itself. The court also pointed out that even in mosques, non-Muslims were not allowed to enter certain places of worship in the mosque premises. Consequently, the High Court had declared that the new rule permitting non-Hindus to enter temples was ultra vires of the powers of the rule-making authority itself. Irrespective of how courts view this issue on the basis of the law, the fact is that Tamil Nadu has some shining examples of interreligious harmony. For instance, in Sikandar Chavadi in Madurai, the procession to the Mandayamman temple begins with the hoisting of a Muslim flag and with the raising of slogans of Hom Shakti and Allahu Akbar. More recently, Bharatanatyam dancer Zakir Hussain donated a gold crown studded with rubies and diamonds to the Srirangam temple. On that note, this is D. Suresh Kumar signing off. I shall meet you in another video. Thank you.